Thank you so much for joining us, all who are watching, and to our witnesses particularly, thank you for being here today, whether in person or remotely. And I want to say a special thanks to the ranking member, Senator Blackburn. This subcommittee has been traditionally very, very bipartisan, and we are beginning our hearings today in a very bipartisan way. The witnesses that we have before us are the result of a bipartisan consensus, and there is nothing partisan about consumer protection. We all want to protect against the abuses and deception and lies that all too often we see in the marketplace. We are completing a year of unimaginable heartbreak and hardship for all Americans. A year of pandemic crisis, healthcare crisis, and consumer crisis. This year of heartbreak for Americans has also been a breakout year for the swindlers and con artists. They have seen it as a bonanza, and in fact, they have made it a bonanza. There have been 460,000 reports of consumer fraud in the past year, according to the FTC, at a cost of more than $411 million, which represents a 45% increase in the numbers of reports, 83% rise in the dollars lost. So these reports show the results of a flooding of online marketplaces with fake personal protective equipment, sophisticated counterfeits, and other kinds of frauds. These sophisticated counterfeits have infiltrated the supply chain, often unchecked by big tech platforms, putting unsuspecting consumers and healthcare workers at risk. Truly, it has become a matter of life and death. As consumers have grown more fearful for their safety, social media platforms have become a mega mall for snake oil peddlers hawking fake cures and prevention. These platforms have been way too slow to respond. They've done too little, too late, and then often only as a result of vigorous prodding, in fact, very strong kicks by consumer advocates and members of Congress, as well as state AGs. Hucksters like Joseph Mercola have spread medical misinformation to millions, denying the science of COVID-19 while reaping profit windfalls, selling expensive vitamins and supplements as cures. One of them he has advertised is this vitamin C liposomol with his name, which he has said will successfully fight COVID, and advise people to take it rather than get the vaccine. To this day, despite FDA warnings, he tells consumers you likely don't need a vaccine. In fact, he creates false fears about the vaccine, and then he offers these supplements, such as vitamin C, as prevention strategies and treatments readily available. They've been shown, he says, to be effective. Of course, he's not only playing fast and loose, he's lying. In protective equipment, we've seen similar kinds of scams. Real and fake protective equipment, which endangers lives. It literally puts lives at risk because the fake 3M devices are no substitute for the real ones. Not only have the social media platforms been enablers, knowing and recklessly enabling these kinds of frauds to occur, but they've also been laggard and lacking in taking action when they had fair notice that many of these frauds were exploiting their platforms. The Federal Trade Commission has been a line of defense, but all too often what we've seen is warnings rather than court action. The time for warnings is over. The FTC must go to court against wrongdoings. It needs to create deterrence through hefty legal penalties and strict court orders, and it needs to refer for criminal action more often and more effectively these kinds of cases. The perpetrators of these frauds don't like to pay money. They don't like to pay penalties. They don't like to pay restitution, but most important, they don't like to be behind bars. And that's what the FTC has to seek. More than baring its teeth, this agency has to use those teeth through the penalties that have been provided, new penalties provided most recently by Congress. So we need to bolster and support the FTC, providing more legal tools and resources where necessary to defend consumers. And as a first step to ensure that the FTC can get consumers' money back when they are scammed, we need to restore 13B authority that was taken away by the Supreme Court when it caved to a shadowy campaign to disarm the FTC. Unless Congress acts, the FTC will have, in effect, both hands tied behind its back. Over the last 4 years, the FTC has secured over $11 billion in refunds for consumers. There is approximately $1.8 billion of American money at stake right now, and I hope that Congress will act promptly and effectively to restore that authority. Let me just say in summary, the path forward seems clear. The FTC must act more swiftly to stop scams, perhaps going to court without Department of Justice authority. It has to seek financial penalties against wrongdoing more vigorously. It has to hold the platforms accountable for aiding scams. And in that regard, we need to re-examine and revise Section 230 to enable victims to go against the platforms as well. And the FTC needs to work with law enforcement to bring criminal penalties as a deterrent. There's a lot of work ahead, and I look forward to tackling it in combination with the ranking member, Senator Blackburn. Again, my thanks for your leadership over the years, Senator, and I turn to you.
Thank you, Mr. Chairman. I want to welcome our witnesses who are with us and also joining us virtually. And I want to thank you and your staff for the work that they have done on pulling this hearing together. People are truly spending more time on the internet than ever before, and many times this is through work or school or just simply connecting with family and friends. But the fraudsters are aware of this, and they are wise to how people are on the internet and where they are vulnerable. And we continue to see this play out many times. Ms. Patton, I know you and your group see quite a bit of it. Even in the earliest days of the pandemic, it was difficult for people to get accurate information about the nature of the virus, how severe it was, where it started, how it spreads. The disinformation took on a life of its own, becoming essentially a media pathogen. It's no surprise that when PPE items and household cleaners were out when you went to the grocery store or the big box, that buyers flocked to the internet to get what they needed. Tennessee has taken the lead in cracking down on some of the most high-profile scandals in this space, and the first consumer action brought by any state attorney general's office in response to COVID-19, Tennessee shut down a hoarding and price gouging practice that deprived rural East Tennessee and eastern Kentucky of hand sanitizer and other essential cleaning supplies. Another Tennessee company falsely claimed that its products could protect surfaces from COVID-19 for 90 days. They falsely claimed that their products were FDA and EPA approved and falsely implied that it was being used by companies like McDonald's and Panda Express. The Attorney General's office immediately launched an investigation. The company settled, paid their fine, and promised to stop making false and misleading claims. Individual consumers weren't the only victims of scam artists. Our federal government has been defrauded in countless instances. The Paycheck Protection Program, or PPP, has saved thousands of small businesses and kept hundreds of thousands of people on the payroll when the economy came to a standstill. However, according to a report issued by the Small Business Administration's Office of Inspector General, nearly 55,000 loans were made to potentially ineligible businesses, totaling more than $7 billion. While I know we're all ready for COVID to be over, it's important that we remain vigilant during this next and hopefully last phase of the virus, and that soon we're all going to see things return to normal. Thank you, Mr. Chairman.
Thank you, Senator Blackburn. I'd now like to call remotely on Chairman Cantwell if she's available. Apparently she is not here as yet. Is Senator Wicker available? If not, let me move ahead to introduce the witnesses. The two who are with us this morning in person. First, Daniel Kaufman, who is Acting Director of the Bureau of Consumer Protection at the FTC. He served for 8 years as the Bureau's Deputy Director, and before that, before joining the FTC in 1998 as a staff attorney, he was a litigator. He spent 4 years as a litigator in New York City. He received his BA from Cornell University and graduated cum laude from the University of Pennsylvania Law School. Bonnie Patton, who is the CEO of Truth in Advertising, graduated from Boston University and received her JD from Boston University and her BA from the University of Pennsylvania. Prior to helping found the Truth in Advertising organization, she spent most of the past 2 decades working as a litigation attorney in New Haven, Connecticut. We're joined remotely by William Kovacic, who is Global Competition Professor of Law and Policy at the George Washington University Law School. Professor Kovacic has taught antitrust contracts and government contracts. Before joining the law school in 1999, he was the George Mason University Foundation Professor at the George Mason University School of Law, and he was a member of the FTC from January 2006 to October 2011, and he chaired the agency from 2008 to March 2009. Kevin Rhodes is Senior Vice President and Deputy General Counsel at 3M. He leads that company's legal team on a global basis, and he has helped lead 3M's ongoing efforts during the COVID-19 pandemic to address fraud, counterfeiting, and price gouging of personal protective equipment, most notably of 3M's N95 respirators, and I held up one of them a few moments ago. Prior to joining 3M in 2000, he was a partner at Kirkland Ellis in Chicago, where he specialized in intellectual property litigation. He received his JD, magna cum laude, from Northwestern University and his BA from Grinnell College. Cynthia Alexander is Assistant Attorney General Consumer Protection Division in the Washington Attorney General's office. She played a significant role in leading her office's response to COVID-19 scams and COVID-related consumer complaints. Prior to joining the Attorney General's office, she served for 17 years as a trial attorney in the Civil Division of the United States Department of Justice. She holds an MBA and a PhD in clinical psychology, and she is a licensed psychologist in the state of Washington. So we welcome all of you, and let's begin with Daniel Kaufman.
Thank you. Chairman Blumenthal, Ranking Member Blackburn, and members of the subcommittee, I am Daniel Kaufman, Acting Director of the Bureau of Consumer Protection at the Federal Trade Commission. My written statement represents the views of the Commission, but this opening statement represents my views and not necessarily the views of the Commission or any individual commissioner. I'm pleased to appear before you today to discuss protecting Americans from COVID-19 scams. My written statement describes the extensive work that the FTC has accomplished and continues to accomplish in combating COVID-related frauds. The FTC's Bureau of Consumer Protection is comprised of 8 divisions and 8 regional offices, and each has been actively working on COVID-related issues. So far, we have brought more than a dozen law enforcement actions, engaged in extensive consumer education efforts, kept the public informed about the scams we are seeing, and have also directed the removal of deceptive claims related to COVID made by more than 350 companies. Our most recent law enforcement action utilized the new civil penalty tool that Congress recently gave us, and we are very thankful for that important new statutory authority, as well as the increased funding that we have recently received. As part of that work, the FTC is committed to expanding its outreach to lower-income communities. Just last month, we launched a new way for legal service organizations to report fraud and other illegal business practices that their clients may have experienced. Through the Community Advocate Center on our complaint intake site, reportfraud.ftc.gov, we aim to get their fraud reports into the hands of law enforcers and connect people with tailored advice on how to try to recover their money. I had hoped to use my opening statement to describe in more detail all of the work set forth in the FTC's recently released COVID report that the agency has done related to the pandemic. Instead, I would like to discuss last week's Supreme Court decision in the AMG matter, which held that returning money to harmed consumers and disgorging the ill-gotten gains of lawbreakers are not authorized by Section 13B of the FTC Act. This decision eliminated the primary tool that the FTC uses today to return money to harmed consumers. Over the past 4 decades, the Commission has relied on Section 13B to return billions and billions of dollars back to consumers in a wide variety of cases, including telemarketing fraud, anti-competitive pharmaceutical practices, scams that target seniors and veterans, and other deceptive business practices. I am a 22-year veteran of the Federal Trade Commission, and it is not hyperbole to say that this decision will dramatically curtail the ability of the FTC to effectively protect consumers. For example, looking at the cases that the FTC currently has in litigation, the Supreme Court's decision, if left unfixed by Congress, puts about 24 active consumer protection and competition litigations at real risk, with potential consumer harms of upwards of $2.4 billion. In addition to the huge challenges presented by the AMG decision, some courts recently have also ruled that the Commission cannot seek injunctive relief under 13B in cases where the unlawful conduct is no longer occurring, even when there is a reasonable likelihood that it will recur. This magnifies the challenges for the Commission. Congress can fix the situation and, at a minimum, restore the FTC to the authority that it has used for almost 4 decades to protect American consumers. And the longer it takes to implement the fix, the longer the FTC will be greatly weakened in our ability to protect consumers. Let me be clear. Although the AMG decision has had a very significant impact on our ability to protect consumers and indeed to protect honest businesses, there are other tools and authority that we will use and are using to do the best we can under these circumstances. The FTC will keep fighting, but there will be more litigation that will last longer and use up more resources. There will be less protection for consumers, and the only benefits will accrue to lawbreakers. Thank you for the opportunity to testify, and I welcome your questions.
Thanks very much, Mr. Kaufman. I'd like to turn now to William Kovacic, who joins us remotely.
Thank you very much, Chairman Blumenthal. My thanks also to Ranking Member Blackburn and the subcommittee members. I'm most grateful for the opportunity to participate in these important proceedings. The COVID pandemic is the latest grim demonstration that catastrophe often inspires serious fraud. And I'd like to discuss several ways that Congress and the FTC, the states, and other law enforcement bodies and their partners can respond to what has been a merciless stress test on the ability of public administration to respond to this type of crisis. In offering suggestions, I immediately acknowledge the admirable efforts already undertaken by the Congress, the FTC, the states, and their partners to protect Americans from exploitation. My first suggestion echoes a comment that the chairman made in opening the proceedings. And that is my belief that serious fraud will only be deterred when we bring the full range of our criminal enforcement powers to bear on the wrongdoers. I think the chair described accurately the state of mind of the wrongdoers here. They have sinister skill, they have utter cravenness, and I don't think they will respond fully if the worst that can happen to them is that we take the money away from them and return it to the Treasury or return it to consumers. In many instances, they squander the assets they've gained improperly, and they hide the funds that they have. I think the only way to deter their misconduct effectively is to take away their freedom through criminal enforcement. Now, as the chair said, the FTC already has a platform, the Criminal Liaison Unit, to encourage and work with criminal enforcement authorities to use their powers on behalf of consumers by bringing criminal sanctions to bear on the wrongdoers. I think an unmistakable lesson of this recent experience is that augmenting that capability, increasing the cooperation with criminal enforcement authorities, with the FTC playing a crucial role in helping set up cases, identify areas for examination, in many instances to assist in compiling a record that will be useful in criminal prosecution, is the only way to bring our fullest and most powerful deterrent to bear on these individuals. Civil enforcement is an important part of the mix, let there be no doubt. But I think our first and foremost strategy in many respects has to be dealing with serious criminals, with serious criminal enforcement process. My second suggestion deals with themes that Daniel and the chair have raised already, and that is we must restore the ability of the Federal Trade Commission to go directly to district court and to receive restitution or to achieve disgorgement, restitution for victims, disgorgement of other assets to place in the Treasury. These measures do have important deterrent value, and they are the best tool that the FTC has at its disposal to achieve compensation for victims. And this must be a priority of legislative drafting in the months to come. My third suggestion is a dramatic expansion of funding and resources for the FTC, along with some ideas about how to spend it. Last fall, before this committee and proceedings convened by Senator Wicker, I suggested that a threefold increase in the budget of the FTC would be appropriate to put the commission in a position to do the work that it must do. And that it was important not simply to add to the size of the professional staff. The commission is blessed with wonderful professionals, and you have one of them seated before you with Daniel Kaufman. But I think it is important to consider bringing the salary levels up to the level, for example, that the Consumer Financial Protection Bureau enjoys, roughly a 20% boost, so that we can recruit the best and, more important, to keep them. What I do with the salaries? I would enhance what are presently the best data collection and consumer education systems in the world. Those are the FTCs. I would use the money to enhance Sentinel, to expand the consumer and business education projects that the FTC has underway. I would invest more in building the data analytics capability that the agency already has to use the information that it has and to apply it more effectively. And I would use the Competition and Markets Authority regime, the data unit there, as a model for doing this. And finally, I would indeed use the money to expand cooperation with state partners, with state and local governments to enforce more effectively. I welcome your questions and those of other committee members. Thank you.
Thanks very much, Professor Kovacic. And now, Kevin Rhodes.
Chair Blumenthal, Ranking Member Blackburn, and distinguished members of the subcommittee. Chair Blumenthal, Ranking Member Blackburn, and distinguished members of the subcommittee. Thank you very much for the opportunity to testify today. 3M appreciates your focus on consumer protection, including critical issues of PPE supply chain integrity and public health and safety. In my role as Senior Vice President and Deputy General Counsel of 3M, I am proud to be a leader of 3M's ongoing efforts to address fraud, counterfeiting, and price gouging of PPE products during the COVID-19 pandemic, most notably 3M's N95 respirators. Hundreds of 3Mers around the company and across the world have joined together to help stop pandemic profiteers seeking to take advantage of the tremendous demand for our products in unlawful ways. Our efforts are designed to help healthcare workers, first responders, and others on the front lines of the fight against COVID-19 get the genuine 3M N95 respirators they need and deserve at a fair price. Our actions against PPE scams are just a part of 3M's overall pandemic response. We are committed to the safety of our employees, healthcare workers, and the public. We are meeting these commitments by responding to the pandemic from all angles. We have increased our global manufacturing of PPE products to unprecedented levels, making nearly 4 times as many 3M N95 respirators than before the pandemic. In the US alone, we are now producing more than 95 million N95 respirators every month, thanks to ramped up production at our facilities in Aberdeen, South Dakota, and Valley, Nebraska. And we are partnering with federal, state, and local governments to help ensure our products are getting to where they are needed the most. With respect to our efforts to address PPE scams, we have published a wide variety of online resources and tips to help the public spot and avoid fraud, counterfeits, and price gouging. We have created and staffed hotlines and web intake forms around the world to help the public identify authentic 3M products from 3M authorized distributors and to report cases of suspected wrongdoing. Since the beginning of the pandemic, we have processed more than 13,800 of those reports. We have referred thousands of them to law enforcement and government agencies. And the effectiveness of the investigations and actions those law enforcement authorities and agencies have taken is a key lesson learned in our view. We've also taken legal action directly against wrongdoers. 3M has filed 33 lawsuits in courts across the country. We have won temporary restraining orders, preliminary injunctions, and final judgments in multiple cases, putting a stop to the defendant's unlawful conduct. In those cases where 3M has recovered monetary damages, we are donating all of those recoveries to COVID-19 related charities. We're also prioritizing the stopping of online scams, as Chair Blumenthal mentioned in his opening comments, that those have been a key focus of our activities as well. We have partnered with e-commerce and technology companies to remove tens of thousands of false or deceptive e-commerce listings, social media posts, and websites. 3M's partnerships with law enforcement and customs authorities have been especially important in addressing the problem of counterfeits. In February, the Department of Homeland Security announced that its special agents had seized 11 million counterfeit masks in operations conducted in 5 states. That investigation began with a suspected counterfeit report submitted to 3M by a concerned respirator buyer. And that example is hardly unique. Since the beginning of the pandemic, raids by law enforcement, seizures by customs authorities around the world, and other actions have removed more than 38 million counterfeit respirators from the market before they can endanger unsuspecting wearers. 3M hopes that by continuing to share our experience, we can help in educating the public and in protecting it from further scams. In my written testimony, I offer a number of lessons learned and suggestions in that regard. highlighting the effectiveness of private-public partnerships, of consumer education, and the need for pandemic preparedness to include specific plans and dedicated resources for law enforcement and government agencies to respond quickly and effectively to the fraud, counterfeiting, and price gouging that unfortunately does take place when demand for PPE so far exceeds supply. I thank you again for the opportunity to offer these views today. Freedom is very proud of our hard work as a leading supplier of N95 respirators and other PPE that are so important to the fight against COVID-19, and of our commitment to continuing to help prevent fraud, counterfeiting, and price gouging before it starts, and to stop it where it is occurring. I will be pleased to answer your questions or to supply additional information for the record. Thank you very much.
Thank you, Mr. Rhodes. And now Cynthia Alexander remotely. Thank you.
Thank you, Chair Blumenthal and Ranking Member Blackburn and the distinguished members of the committee for this opportunity to testify about COVID scams and how we can work together to protect consumers from fraud. I'm an Assistant Attorney General in the Consumer Protection Division of the Washington State Attorney General's Office. And here in Washington State, our courts are fond of repeating a quote from the 1914 House Conference Report on the FTC Act regarding unfair business practices. And the quote is, "There is no limit to human inventiveness in this field." And I think it's fair to say more than 100 years on, this observation is still on point. It certainly is in our state. In Washington, as in many other states, the Consumer Protection Division of the Attorney General's Office houses a consumer resource center that receives complaints from consumers about businesses that operate in Washington and offers a voluntary complaint resolution process. And in the early months of the pandemic last year, we began to see our complaint volume double. A significant portion of the complaints we received related to price gouging or failure to refund fees paid for travel or events or memberships that were affected by COVID restrictions. But I'm going to focus today on a few of the COVID-related scams we've seen in Washington. One area of particular concern for our office has been the marketing of unsubstantiated COVID treatments. We investigated a number of individuals and businesses engaged in this conduct, and we used a combination of enforcement tools, including cease and desist notices from the Attorney General, warning letters, and lawsuits in our efforts to stop this conduct and protect our consumers in Washington. For example, early in the pandemic, a Washington company began promoting a virus-destroying drink to consumers, and the company's chief research director said in an email sent to Washingtonians, "I think this drink is so incredibly promising for protection from this pandemic that I'm giving it to my pregnant wife and 19-month-old daughter daily. So be sure to click the link below to get the details." And we also received complaints about an allergy clinic that was advertising treatments for COVID-19. And when our investigator called to ask what treatments they were offering, they said immune system boosting. These two matters we resolved with a cease and desist letter and a warning letter in one case, a cease and desist letter in one case, a warning letter in another case. But we did file a lawsuit against an individual who announced on Facebook that he had developed a COVID-19 vaccine and offered to vaccinate consumers for $400 each. And in the course of the investigation, we learned he admitted that he had injected about 30 consumers with this product. So the Attorney General filed a lawsuit against him in Washington Superior Court that resulted in a consent decree that prohibits this kind of conduct and required him to provide full restitution to consumers for the amounts they paid, as well as pay civil penalties. And now that COVID vaccines have become available, we're seeing an increasing number of vaccine-related scams. For example, we've become aware of blank or fraudulently completed vaccine cards bearing the CDC logo being offered for sale on some online platforms. And so earlier this month, 46 state attorneys general signed a letter to companies with major online platforms expressing these concerns and requesting that the companies take immediate action to monitor their platforms for these fake vaccine cards, to promptly take down any ads or links for them, and to preserve all their records. We've also become aware of COVID-19 vaccine survey scams in which consumers who have been vaccinated receive a text or an email asking them to complete a survey about the vaccine they just received. And typically the consumers are then offered a free reward but asked to pay a nominal shipping fee, and then they're billed for the fee but never receive an award. And then most recently, we've heard about portable COVID testing operations in our community that aren't endorsed by local or state health departments. These operations have apparently set up testing tables in neighborhoods and parks, and it's been observed by local health officials that the testers may be collecting and holding personal information insecurely, falsely claiming to be with public health and despite offering free testing, have fine print in their documents that indicate that consumers could be billed. So these are just a few examples of the types of COVID schemes we've seen. And so combating consumer fraud requires vigilance and persistence and partnership and collaboration with other federal and state enforcement agencies. So I want to take just a second to say one important tool for us is our collaboration with the FTC. And because of that importance of that partnership, many of the states are very interested in the FTC's 13B authority to obtain equitable monetary relief. Washington was one of 28 states, joined 28 other states and the District of Columbia in filing an amicus brief in the AMG case, because our enforcement efforts are very much fortified by having a strong federal partner in the FTC. And we benefit from the FTC's independent authority to obtain redress for consumers. It's a critical supplement to the state's efforts because the FTC can obtain restitution for consumers for unlawful activity that spans multiple states. So thank you for the opportunity to testify about these important issues, and I'd be happy to answer your questions.
Thanks very much, Ms. Alexander. And now to Bonnie Patton of Truth in Advertising. Thank you for being here.
Chairman Blumenthal, Ranking Member Blackburn, members of the subcommittee, on behalf of Truth in Advertising, I welcome the opportunity to appear before you to highlight deceptive marketing schemes that have arisen during this pandemic and to sound the alarm that the worst is ahead of us as the FTC is now powerless to claw back ill-gotten gains from wrongdoers under Section 13B of the FTC Act. TINA.org is a nonpartisan, nonprofit consumer advocacy organization whose mission is to combat deceptive advertising and consumer fraud. The list of deceptively marketed products and services exploiting this pandemic that Truth in Advertising is tracking is extensive. CBD products marketed to military veterans as a coronavirus treatment, wellness centers targeting first responders with IV vitamin drips to protect against COVID-19, Amazon and eBay sellers falsely claiming that their PPE is FDA approved, and sham wellness kits targeting seniors. The number of scams has been so prolific that the FDA and FTC have had to issue more than 350 warnings pertaining to fraudulent coronavirus tests, treatments, and vaccines. Unfortunately, the deception does not stop with outrageous health claims. Many are exploiting the economic desperation wrought by this pandemic. Multi-level marketing companies claiming that people can earn full-time pay working part-time. Lending companies deceptively using the CARES Act to exploit debt-ridden college students. Vaccine survey scams stealing personal information and money. And imposter scams, where fraudsters contact grieving families under the auspices of the Funeral Assistance Program to steal personal data. To make matters worse, the FTC has lost a mainstay of its enforcement authority, the ability to make victims whole under Section 13B. We must not lose sight of the fact that AMG directly impacts more than 4.5 million struggling Americans in all 50 states. This decision permits loan shark AMG to pocket $1.3 billion that it stole from constituents in your communities. These victims needed money to pay the rent, to put food on their table. And now they're left with nothing pursuant to this decision. And the victims of AMG are not alone. Another 2.7 million consumers illegally enrolled in credit monitoring services will not see a penny of the $5.3 million ordered in restitution in the Credit Bureau case. Likewise, consumers who were charged hundreds of millions of dollars as a result of AbbVie's use of sham litigation to illegally maintain monopoly will not see any refunds. In fact, in the AbbVie trial court decision, which awarded the FTC $448 million, the judge stated that if equitable relief was not permitted in 13B cases, quote, this interpretation would eviscerate the FTC Act, end quote. And that's just 3 cases. The FTC has approximately 75 13B cases currently pending, with more than $2 billion in exposure, including the antitrust case against Facebook. Unless Congress acts to fix 13B, many of these cases will simply disappear. And our senior citizens, our military veterans, struggling parents, and honest business owners will likely pay the price. During these unprecedented times, it is imperative that the FTC not only quickly stop deceptive marketing as soon as possible, but also expeditiously return ill-gotten gains to victims. At present, the FTC simply cannot do that. And as a result, your constituents and the honest businesses in your communities will suffer the consequences. Congress must provide a broad and permanent 13B fix. Thank you, and I look forward to answering your questions.
Thank you very much, Ms. Patton. Thank you for that excellent description of the explosion that we're seeing in frauds and the vulnerability and lack of enforcement that will result from the 13B decision by the Supreme Court, which could eviscerate large areas of enforcement. And that challenge to us in Congress has been highlighted by Mr. Kaufman and Mr. Kovacic as well. And certainly it ought to be at the top of our priorities as we consider this crisis. And ironically, the increasing hope resulting from the vaccines has only accelerated the frauds that we're seeing. In fact, swindlers have stolen money from senior citizens by promising them at-home vaccinations. There have been pitches to schedule vaccination appointments and checkups, committing identity theft and counterfeit vaccination cards and fake negative results of tests are increasing online. So the challenge is not diminishing with our ability to potentially conquer the pandemic through increased vaccinations. And you mentioned, Ms. Patton, the 350 warning that the FTC has directed to companies to remove deceptive claims. Mr. Kaufman, let's be very blunt. These warnings are just a slap on the wrist. So far, the FTC has brought only 1 case under the COVID-19 Consumer Protection Act, and I hope that will be a start in increasing vigor by the FTC. I agree totally that we need to increase the resources available to the FTC, as Mr. Kovacic has emphasized. The president's apparently going to seek an $80 billion increase for the IRS. I would suggest something comparable for the FTC in the way of resources. But what plans does the FTC have to use increased penalties and criminal referrals?
Thank you for the question, Senator. We have more cases in the pipeline that will be utilizing the new civil penalty authority that Congress has given us. We think it's a very important tool that we definitely will be utilizing. I also do want to mention that the 350 companies that received warning letters, we're watching them closely to make sure that they don't recur. And if they do, we will also be bringing law enforcement against them as well.
But if those warning letters and the scrutiny are just the cost of doing business, it won't be a deterrent to them. Criminal referrals and increased penalties are what will put them out of business.
And I do agree very much. Increased criminal referrals is something we do. We have a unit at the FTC, the Criminal Liaison Unit, that works with criminal law enforcement throughout the country to get them interested in our cases, and that's something that we can and should do more of.
Let me turn to the social media platforms. We've all seen the fake cures, the fake PPE, now fake vaccination cards. Right now, for these platforms, there's no cost to inaction. They seem to pay attention only when Congress or the state AGs literally kick them in the butt. And often it takes multiple kicks in the butt. Let me ask Ms. Patton and Mr. Kovacic, what changes should we make in the Section 230 immunity that right now these platforms enjoy?
Well, I think that 230 definitely needs some fixing. Tina.org's position is that platforms that profit from the goods and services that they're deceptively marketing should not be able to hide behind that 230 immunity, such that the fix that's needed is that if it deals with commercial speech in which a platform is making money, that they should not be able to use 230 at all.
Professor Kovacic?
Thank you, Mr. Chairman. I don't know if it's simply in the context of Section 230, but I think it's appropriate through perhaps a variety of different legal steps to bring responsibility to bear on intermediaries who are aware or should be aware of the falsity of claims that are being made, to exercise care in denying the use of their platforms to those who make these kinds of claims. I'm not sure if 230 is the only specific vehicle to use. I haven't spent much of my work studying that carefully, but I can think of other legal concepts and principles where we bring responsibility to bear on third parties who know or should know that the conduct taking place through the medium or vehicle that they control is fraudulent, and situating responsibility with the individual or institution that's in a position to control the behavior, that's aware that there's serious harm that can flow from the behavior, I think is entirely appropriate. And I expect that you and your colleagues will be looking at a number of different ways in which this kind of responsibility can be brought to bear on a variety of different actors, including information platforms.
Thanks, Professor Kovacic. Senator Blackburn.
Thank you, Mr. Chairman. I find it so interesting. Section 230 comes up in so many different arenas. So thank you all for that. Mr. Rhodes, I want to come to you first. I appreciate your comment about pandemic profiteers and thought that was an artful term and really a very fitting way to kind of couch some of what we've seen taking place online. And we know this wasn't, pardon me, our first pandemic. It will not be the last. And so education, consumer education, is a big part of this responsibility. So I wish you would talk for just a minute about how you all as a corporate entity pardon me, view your responsibility to educate people on how to detect something that is an actual real item, authentic, and something that's a fake. Mr.
Thank you.
Rhodes? Yeah, thank you.
Thank you very much for the question, Ranking Member Blackburn. So early on in the pandemic, our Chairman of the Board and CEO, Mike Roman, said 3M has a unique responsibility to respond to the pandemic from all angles as a leading supplier of personal protective equipment, including N95 respirators. Yeah. We have taken that responsibility and those words to heart, and that includes helping to do what we can to ensure that brave frontline workers get genuine products at a fair price. And part of that is educating, both the public and procurement officials as to what we're seeing in the marketplace, what we're going after by way of frauds and scams and counterfeits and the like. So, part of our activities have involved not only putting information on our website, we've posted tips on how to spot fraudulent offers, typically characterized by get the money up front and then disappear before the buyer realizes there's no product. Those involve upfront payments into escrow that the seller pays into and the buyer pays into and the seller can access, and other
Okay, so,
schemes like
sir, I want to interrupt you right there. So you are conducting education to both the individual consumer and also to purchasing agents. Is that correct?
That's correct, and
Okay.
we have
All right,
worked with
let me
state
move
general
on. My
purchasing agents
time,
too.
yeah, my time is limited. I want to move on. Okay, so Mr. Kaufman, when you all are trying to go through your enforcement, what kind of participation are you getting from the online marketplace, from vendors that have third parties that are selling?
So answer would be twofold. When we see bad claims, in addition to reaching out to the party that's involved in the bad claims, we are also contacting the platforms to make sure that they're aware that there's bad activity on their platform.
And do they respond appropriately?
They have responded appropriately, but I wish they would respond more without being invited to respond by the FTC.
Okay, do they come to you with due diligence or information on their own? We think we have someone who needs to be investigated.
We get occasional referrals from platforms and from companies as well.
Okay, all right. And Professor Kovacic, I want to come to you on this. I know you're going to tell me you need more budget and staff. That's going to be a part of your answer. And Mr. Kaufman, to you. When we look at what the FTC is doing, one of the things that we have discussed for a couple of years now is the need to scale enforcement. So as you look at this, other than budget and agents, what kind of authorities do you need? And Mr. Kaufman, you first, and then Professor
So
Kovacic.
certainly the most pressing issue right now is restoring our 13B authority.
Okay.
Without that authority, it is a huge blow to the FTC. And there are other areas where we could definitely use civil penalty authority, most notably data security and privacy violations. To be able to penalize first-time privacy violators would be a huge benefit for consumers and for the agency.
Okay. Professor?
I would echo Daniel's comments, put those on my list as well. I'd simply add, I would like to see the development of a comprehensive strategy that brings together the full community of law enforcement authorities to decide in a more collective way, what are we doing now and what do we have to do to be more effective? I think that would be very profitable, a way to make sure we got the full value for the additional expenditures.
Thank you. Thank you, Mr. Chairman.
Thanks, Senator Blackburn. Senator Klobuchar.
Thank you very much. Thank you to all our witnesses. Welcome to Mr. Rhodes from 3M company in my home state, and good to see you again, Mr. Rhodes. Thank you to the chairman and to the ranking member for holding this really important hearing. It couldn't come at a more important time, as you point out, with the Supreme Court decision with 13B. Mr. Kaufman, in your testimony, you highlight that the FTC has sent out more than 350 warning letters directing companies to remove deceptive claims from fake coronavirus treatments to ads for products that were never delivered. How do these companies react to these warning tools, and why is 13B so important?
So the companies, to their credit, to the extent that we want to give them credit, have been very responsive. The response has been overwhelmingly positive, and within 48 hours, the claims are removed. So it has been highly successful from that perspective. But in terms of 13B, there is a lot of litigation we have ongoing that relies solely upon 13B for monetary relief. So rather than getting millions and millions or tens of millions of dollars for consumers, we will be stuck getting nothing if there's no congressional fix to.
And do you have any sense of how much money could be at stake, a range? I know you can't put an exact dollar figure.
So, well, for the past 5 years, we've given back $11 billion with a B dollars back to consumers. So I would estimate it's certainly hundreds of millions per year. That seems to be a fairly conservative estimate.
And that's going forward, of course, too, not just going backwards.
Correct.
And because of the pandemic and some of this fraud that's going on that we've identified, is it possible you'd even have more than usual?
It is certainly possible. We are always looking for the cases that cause the most harm to consumers.
Okay, very good. And Professor Kovacic, thank you for joining us again. You recommend a significant increase in the FTC budget in your testimony. I agree with that. Senator Grassley and I have this bill, the Merger Filing Fee Modernization Act, which time has come. It would not be everything. A lot of what you're talking about, I think, would belong in the appropriations process. But what this would do would increase the budget of each of the FTC and the Antitrust Division by $67.5 million. And it's paid for, actually, in this case, not by taxpayer money, but by an increased merger filing fee on the biggest deal. It actually helps some of the smaller deals. And I call for even more, of course, a $300 million increase to the FTC budget in the appropriations process. But could you go even further? Could you talk about why this is so important at this moment of time, not just from the pandemic fraud cases you're seeing, but also from what you're seeing with those antitrust cases? I think it's so important that the FTC, under Chairman Simon, brought the Facebook case, but I bet that you could use nearly all the personnel in the FTC to work on those cases, and then we'd have no one left for anything else. So could you talk about the importance of this increase in budget?
Yeah, thank you, Senator Klobuchar. I'm thinking from my perspective as someone who started his career at the FTC in the 1970s, and I have watched since the efforts of our public institutions to do expansive, ambitious things with modest resources. And I think as a starting point as a nation, we have to realize that if we want the equivalent of superior results, we've been talking in the last couple of years about the equivalent of a public policy moonshot, to put competition law in a much different place, consumer protection in a much different place. We look at our experience that with NASA, that was expensive, but it was worth it, arguably. And I think to have the conversation that says it is worth it for our nation to spend what it takes, not just in aggregate numbers, but to recruit and retain the personnel that we're going to need to drive these programs home successfully.
Thank you.
And I think if we're not willing to spend more, and suppose we don't spend triple the agency's budget, if we don't take the steps that you have suggested, step by step, I think we're going to find ourselves in a chronic position that we do in public policy, where we have grand policy aspirations and we scratch our heads and say, why isn't it working? Well,
Okay.
in part, it's not working because we're not willing to pay for it.
Thank you. Mr. Rhodes, hometown company, in your testimony, you note that 3M partnered with the U.S. Department of Homeland Security to help seize approximately 11 million counterfeit 3M N95 masks. And in January, 3M helped Minnesota avoid buying nearly 500,000 counterfeit N95 masks from a fraudulent vendor. Can you speak to the important role of public-private partnerships in combating fraud?
Yes, thank you for the question, Senator Klobuchar. That has been an integral part of our efforts from the beginning in processing those 13,800 reports, forming close partnerships with law enforcement and with agencies has really allowed us to extend beyond what we can do with our civil litigation authority. And the opening comments I thought were spot on, that the criminal enforcement really helps to make the difference to stop the bad actors. And so that's been a critical part of our efforts from beginning last March, when we sent a letter to the Department of Justice, to the National Association of Attorney Generals, National Governors Association, reaching out. We conducted briefings, formed working relationships with the DOJ task force, with Department of Homeland Security Investigations and their National IPR Center, as well as Customs and Border Protection. And those have really been among the most effective actions that we've been able to take.
Thank you. Thank you. And just last, I'll just put this one on the record because my colleagues are waiting to ask questions. But Ms. Patton, thank you for your work. And I will say, Senator Lujan and I have done a letter after a hearing that he conducted on misinformation on vaccines, and I'll follow up with you on this, but just some astounding findings that maybe if we could take 12 accounts down or get the social media companies to do it, we would be in a lot better place. So thank you.
Thanks, Senator Klobuchar, and thanks for your very thoughtful book, which deals with many of these topics.
Thank you.
Senator Thune.
Thank you, Mr. Chairman. Mr. Kaufman, following the enactment of the TRACE Act in December of 2019, the FTC's seen a drop in robocall complaints. Could you elaborate on some of the FTC's recent robocall enforcement actions?
Sure. We are engaging quite a lot with the Federal Communications Commission, with the FCC and with DOJ on a number of robocall issues. We've got several cases in litigation, and we have a lot of cases in the pipeline that will be challenging more bad robocall conduct. So it's an area we are very actively involved in.
Could you speak to the FTC's efforts on engaging on that issue with industry initiatives like the Robocall Trace Back Group, and whether this public-private partnership has been successful in identifying illegal robocallers?
Absolutely. It has been a very successful partnership. It's been a robust source of leads and helpful information to allow us to build successful law enforcement actions. So highly successful.
Okay, good. Justice Breyer's opinion last week regarding the FTC's authority to seek equitable relief cited the Safe Data Act, which is comprehensive privacy legislation I've sponsored with Senators Wicker, Fisher, and Blackburn, as an example of Congress considering providing for a fix to the gap in the FTC's 13B authority. Mr. Kaufman, in your view, would this particular provision be helpful to the FTC after the Supreme Court's unanimous ruling that the FTC could no longer secure consumer redress in federal courts under the FTC's 13B authority?
Absolutely. We really do appreciate the inclusion of 13B reform in the Safe Data Act and very much are very supportive and think it's a very important thing for Congress to take up.
Mr. Rhodes, I appreciate all the work that 3M has done throughout the pandemic to increase its production of PPE to support individuals and frontline workers. In fact, last November, I had the opportunity to visit 3M's manufacturing facility in Aberdeen, South Dakota, to see the expansion of 3M's N95 mass production lines. At the same time you were increasing your manufacturing capabilities, scammers were trying to exploit the pandemic by offering a number of fraudulent products. What steps did 3M take to combat fraudulent activity during the pandemic? And can you talk about your partnership with law enforcement officials when identifying fraud?
Yes, thank you for the question, Senator Thune. So our efforts to address the pandemic really started with getting information out there. We established our website, our fraud hotlines to both allow customers to verify that offers of product were authentic and from authorized 3M distributors. We put online information about how to spot fraud in all of its forms, how to spot counterfeits. We published the list prices for our commonly sold N95 respirators so that customers could identify and avoid inflated pricing. At the same time, once we established intakes for reports of suspected fraud, we reached out, as I mentioned, to the Department of Justice, to state AG's offices, to DHS, to CBP, to the FBI, and started a process of sharing information, of referring reports. We've referred thousands of reports, which has really extended the reach and effectiveness of our actions. We've also brought our own actions in 33 lawsuits in courts across the country, and we've been very successful in stopping the unlawful activity, and we've donated all of our recoveries in those cases, monetary recoveries, to COVID-19 related charities. We've also partnered with online retailers, internet companies to take down tens of thousands of false or deceptive product listings, social media posts, websites. And so it's been really a case of addressing fraud, price gouging, and counterfeiting from all angles.
Mr. Kaufman, there have been a number of discussions around vaccine passports since the Biden administration took office. Vaccination is key to ending this pandemic, but the idea that a vaccine passport or lack thereof could be used to track or restrict Americans' movement is concerning. I understand several technology companies have been working to develop digital tools or passports, which may be appealing to consumers as they seek ways to facilitate their return to normal activities. And while convenient to the consumer, I am concerned about the privacy and security of that health data that the consumer may opt to provide these companies. The FTC taken steps to conduct oversight of the privacy implications of digital vaccine passports?
At the moment, we have not done anything publicly about it, but it is an issue that we are very concerned about. Obviously, there are enormous implications involving vaccines and privacy issues. We've also been active in a lot of other health privacy areas. We brought a recent case, Flow, involving an online telehealth app that collected a lot of information from hundreds of millions of people. So the issue of health and apps is an area we're very focused on, and I think you raise a very important issue that we will be looking at.
Good. Okay, I'm glad you're going to be looking at it. Thank you, Mr. Chairman.
Thanks, Senator Thune. And now Senator Markey.
Thank you very much, Mr. Chairman. Thank you for holding this very important hearing. A year ago, I sent a letter to the Federal Trade Commission urging it to develop and implement a comprehensive plan to stop bad actors from preying on innocent consumers with COVID-related scams and price gouging. Since then, the Commission has taken a number of important steps to stop this type of behavior, including issuing warning letters and charging a scammer who deceptively marketed a fake COVID treatment. But there is so much more that needs to be done. The Commission also needs to address consumer protection threats that have indirectly arisen as a result of the pandemic. Specifically, we need to stop websites that are taking advantage of kids who are online and on their devices more than ever during the period of distance learning. I recently sent a letter to the Federal Trade Commission urging it to investigate whether Google violated Section 5 of the Federal Trade Commission Act by misleadingly marketing children's apps as compliant with the Children's Online Privacy Protection Act, a law which I authored, despite evidence that many of those apps appear to illegally track children and share their personal information without consent. Mr. Kaufman, as children's time online skyrockets during this pandemic, is the Federal Trade Commission committed to cracking down on platforms that are unfairly manipulating kids and deceiving parents while they do it?
Absolutely. I agree very much with you. What has happened from the pandemic, everybody has gone online, and the privacy and security issues have really been magnified by the movement of everything online. So I'm very familiar with your letter. I can't comment on a specific investigation, but issues of children's privacy are very important to myself, to my bureau, and to our acting chairman.
Okay, great. Thank you. Last week, the Supreme Court stripped the Federal Trade Commission of its ability to obtain monetary relief for victims of scams under Section 13B of the Federal Trade Commission Act. Under this ruling, the Federal Trade Commission will operate without its primary tool for compensating cheated consumers. The Supreme Court's decision was nothing short of a gut punch to the Federal Trade Commission and to the consumers which it serves. I look forward to working with Chair Cantwell and Subcommittee Chair Blumenthal and all of my colleagues on this committee to quickly enact legislation that restores the Federal Trade Commission's rightful authority under Section 13B. But until Congress acts, it is imperative that the Federal Trade Commission uses its full authority to deter bad actors from engaging in illegal activity. We need to stop these scams before they happen. Federal Trade Commissioner Chopra has proposed that one way the Federal Trade Commission can deter harmful behavior is by using the Commission's penalty offense authority. Under the Federal Trade Commission Act, if the Commission formally condemns a particular illegal practice, in one case, other companies who knowingly engage in the same practice can face big fines. Here's an example. When a company recently posted fake positive reviews that tricked consumers into buying its products, the Federal Trade Commission issued an order condemning that practice. Using its penalty offense authority, the FTC could potentially now issue serious fines against any company that knowingly defies the Federal Trade Commission by posting fake reviews for their own products. In other words, Using penalty offense authority, the Federal Trade Commission could potentially put whole industries on notice and hit companies where it hurts if they scam consumers. Mr. Kaufman, what are your thoughts on this approach? And is the Federal Trade Commission currently inventorying existing orders to see if it can use them to collect civil penalties from scam artists who are operating today?
The penalty offense authority is one of the additional tools that we are very closely looking at to make sure we can do everything we can in our power to protect consumers despite the loss of 13B. One issue I have with that authority is that it gives you penalties. You know, at the FTC, one of our first priorities, we want to stop the bad conduct and get money back to consumers. Penalty authority doesn't allow us to do that, but it is a good alternative given the unfortunate decision of the Supreme Court last week.
Thank you, Mr. Kaufman. Again, I just wish that the FTC now would use the penumbra of the authority of the Federal Trade Commission Act to protect consumers wherever possible, while simultaneously I realize that it's imperative that we pass legislation to empower the FTC to ensure that it can get money back from consumers who have been bilked, and I'm looking forward to working with Chairman Blumenthal and Chair Maria Cantwell in order to accomplish that goal. Thank you.
Thanks, Senator Markey. Thanks for those excellent comments. And now Senator Lujan. We may be having technical difficulties with Senator Lujan. While we're waiting, let me ask a question. I think it's pretty clear from the testimony that we've heard today and everything we know about the FTC that the Supreme Court decision really is an existential threat to the FTC and to consumers. And if we do nothing else in this subcommittee, we need to reauthorize the FTC's authority to protect consumers and put money back in their pockets. That's essentially what 13B enables the FTC to do, put money back into consumers' pockets for their losses. The money that results from penalties goes to the federal government, not to consumers. It's a deterrent, it's a good means of punishment, but consumers see none of it. Let me ask Assistant Attorney General Alexander, because you are doing what I did for 20 years as Attorney General of the state of Connecticut, which is to put money back in consumers' pockets. Could the state attorneys general fill some of the gap left by the Supreme Court's decision in restricting FTC authority to provide restitution if the FTC were to share more of its cases, to refer more of them, and perhaps even for you to seek criminal penalties if the FTC fails to do so?
Thank you for the question, Senator. Yes, I mean, the states do have restitution authority. Our state in Washington, our courts give us very broad, equitable give the courts broad, equitable authority to provide restitution to consumers. But I will say that, you know, without the FTC being able to seek that form of relief, you know, the states sort of become the primary source of restitution. And while we devote considerable effort to consumer protection, the states can't do everything. And, you know, in some cases, the FTC Act is broader than a state's Consumer Protection Act and reaches farther, reaches into professions that some states' Consumer Protections Acts don't cover. And, you know, the presence of a lot of regulators pursuing restitution allows every regulator to focus their efforts on different schemes, you know, and broaden the range of conduct that can be investigated and prosecuted. And you know, the combined efforts of the federal government, the FTC, and the states create a powerful deterrent effect. And when there's one less regulator with the authority to deprive wrongdoers of the fruits of their illegal conduct, that deterrent effect necessarily weakens. I know you asked about criminal prosecution. I'm a civil attorney and I can't really speak to that specifically, so I'm going to leave that question maybe to my FTC colleagues.
Let me ask you, Ms. Patton, you raised the issue of independent litigating authority. How important could that be to the FTC?
I think it's vitally important to the FTC. When harm is done and consumers need help, time is of the essence. The FTC should not have to ask permission to go in and deal with harmful conduct, and they need to get that money to consumers as quickly as possible. And without independent authority, that cannot happen.
You know, your organization is in the business of educating, and it does extraordinary work in raising warnings to consumers and making sure they know about these scams. Why is education not enough?
Education is not enough because our 320 million consumers in the United States are continually scammed, and they need to be made whole. And education doesn't do that. So without 13B and without a functioning FTC, that's not going to happen.
And part of education is to lead consumers to report wrongs against them, which enable the FTC and state law enforcers to take action to stop the scammers, correct?
That's correct. The Consumer Sentinel network that the FTC relies on all the time is based on consumer complaints.
You know, one may wonder, given all that's been said about 13B authority, who's against restoring it and why?
Criminals?
Criminals, scammers, the payday lenders who exploit working families, the for-profit colleges that prey on veterans, the fake vaccine card perpetrators, or the other kinds of con artists that prey on seniors, and without trying to disparage anyone unfairly, the Chamber of Commerce has said in a letter to the committee, in fact, just before last week's FTC oversight hearing, that it opposes any action on 13B. I recognize that Acting Chair Slaughter and Commissioner Phillips disagreed with the Chamber of Commerce in their testimony, but regrettably, they were provided with that letter just minutes before their testimony. I would be interested to know, Mr. Kaufman, whether you have a further rebuttal to the Chamber of Commerce.
Absolutely. I could spend, unfortunately, far too long with my rebuttal to that letter. I strongly disagree with their propositions. At the outset, they're fundamentally saying that we should not be able to get money from companies unless they engage in egregious fraud. So unless we meet that standard of egregious fraud, we shouldn't be able to get money back from consumers. And I think that is just bad policy. The issue when consumers are deceived is not what was the mens rea, what was the mental state of the company that engaged in the bad conduct. You know, who should bear that burden? The company that deceived consumers or consumers who relied upon that company and made a deceptive purchase? It is consumers who should get their money back, irrespective of the mental state of the advertiser. So I could not disagree more with so many of the propositions in the Chamber's letter.
And one might ask, what is non-egregious fraud? The garden variety exploitation of seniors or veterans or COVID sufferers?
Absolutely. In the advertising area, that is an area where we think it would be particularly challenging. If there is a bad study that a company is relying on, can you say that it was fraudulent for them to rely upon that study? It creates very challenging litigation issues. I've litigated health claims for about 7 years at the FTC. I've seen firsthand how challenging it is to bring these cases, but then to increase the burden and require some showing of intent on behalf of the company would be unacceptable.
In effect, what the Chamber of Commerce wants to do is convert 13B into a criminal statute.
I haven't thought about it from that perspective, but I agree with your commentary.
Requiring mens rea or criminal intent for there to be a violation, which is unheard of in prior consumer protection jurisprudence. If that were the case, state attorneys general would be straitjacketed in everything they did, and the FTC would be severely undermined. Let me turn to Senator Lujan. I'm told he is available. Senator Lujan.
Thank you so much, Chairman. I very much appreciate your leadership and this important hearing that we're having today. I also want to recognize Ranking Member Blackburn for calling this hearing to explore actions we can take to stop COVID-19 related scams. It's critical to understand how we best protect our communities in times of crisis, and I look forward to working together on this topic. Even as the FTC tackles this unprecedented crisis of fraud and abuse against all Americans, we still don't understand the full scale of this crisis. That's why, as a House member, I introduced the bipartisan Protecting Indian Tribes from Scams Act to better understand the scope of scams targeting tribes and tribal members, and to create a roadmap for Congress to put an end to these schemes. The House passed this bill last year, but we still have more work to do. Mr. Kaufman, can I get a commitment from you to work with me on this issue?
Absolutely. We'd be very happy to do so.
And last year, I introduced the Stopping COVID Scams Act so the FTC could go after scammers quickly and decisively. And I'm glad that parts of that bill were incorporated into the Consolidated Appropriations Act in December. Critically, the FTC now has civil penalty authority. And I was glad to see that the Commission brought its first action seeking monetary penalties under its new authority targeting deceptive COVID-19 marketing of vitamin D and zinc products. We can't just give scammers a slap on the wrist, especially when people's lives and livelihoods are on the line. Mr. Kaufman, should Congress expand the FTC's present civil penalty authority to make it permanent and increase its scope beyond the COVID-19 health crisis?
So I do think there are areas where the FTC could definitely use civil penalty authority. Data security and privacy first-time violations are an area where I do think civil penalty authority is appropriate. I'd be glad to discuss with your office other areas where it might be suitable for the FTC to have civil penalty authority against first-time violators.
Appreciate that. Mr. Kaufman, as we recently explored in the hearing in the Communications Subcommittee, misleading and contradictory information about the coronavirus on social media platforms and broadcast media has done real harm. Fake claims have gotten in the way of public health professionals trying to do their job and protect our communities. That is why last week, Senator Klobuchar and I requested information from Jack Dorsey and Mark Zuckerberg about why they have failed to take action against a small group of 12 accounts responsible for up to 65% of anti-vaccine content on their platforms. Many of these accounts turn their lives into profit by selling supplements, books, and other miracle cures. This needs to stop. So my question actually is to Ms. Patton. Do you have any recommendations on steps Congress can take to ensure online platforms address misinformation, super spreaders?
Well, I think the very first thing Congress needs to do is fix 13B. After that, I think that broad civil penalty authority to the FTC would go a long way in deterring these platforms and social media companies to do the right thing. And I think that a civil penalty fund that could reimburse victims of these frauds that you're talking about would also be appropriate.
Mr. Kaufman, do you have a response to that?
Yeah, I definitely agree strongly on the civil penalty fund. It's a tool that other agencies have where civil penalties can go to the agency to disperse money to consumers that were harmed. So I think that would be, and again, I'm speaking for myself and not for the commission, but I do know the acting chair is very interested in that as well. But a civil penalty fund would be a highly effective tool for the agency and for consumers.
In New Mexico, we started seeing COVID-19 scams as early as last March. They tried to scare seniors that they would lose their Social Security payments, and it wasn't true. They tried to sell miracle cures. They were lies. Especially in rural communities, many of these scammers reach their targets not over the internet, but on the telephone. Robocalls aren't just a nuisance. They are used to take advantage of elderly and vulnerable populations when they're most at risk. I'm encouraged that the FTC is taking action against companies that enable those calls, including voice over internet protocol providers. However, it looks like the number of illegal calls are on the rise once again. Mr. Kaufman, what additional tools does the FTC need to fight illegal robocalls?
A lot of the challenges in fighting robocalls are technological, and we are coordinating closely with the FCC, and we do have a lot of cases in the pipeline on robocall issues. But on the other issues you raise, I think education is a very important part of the FTC's mission, and it's important that we not just put information on our website, but that we're reaching out to consumers, to different communities, to share the information about hang up the phone when you get a robocall. So one thing we've done is we've mailed postcards to hundreds of thousands of consumers who are in neighborhoods which have low internet access. So we've appeared on a lot of radio shows in order to get the message out to consumers that might not go to our website to find the information.
Thank you, Mr. Chairman. I yield back.
Thanks a lot, Senator Lujan. A couple of final questions. I appreciated the acting chair's announcement about the Consumer Community Advocate Center. I hope you're familiar with it. And we all recognize that fraud actually exploits the most vulnerable and hard to reach communities. I'm hoping that the FTC can partner with leaders in local communities, faith leaders, senior citizens leaders, and advocates. What is the plan for getting the center started, the Community Advocate Center?
So the Community Advocate Center, we announced it about a month ago. It's a way for legal service organizations to file complaints with the FTC on behalf of their clients and get advice back about what their clients should do. We kicked it off a month ago. We've already signed up 30 different organizations, and we have support from a lot of national organizations as well. So it is just starting up, and we think it has a lot of promise to get us information about frauds that are targeting low-income communities who may be less likely to report to the FTC or to other law enforcement agencies.
Thank you. And finally, the funeral rule. The commission requested last summer comments on changes to the funeral rule. Does the commission intend to make changes to that rule?
I can say that the rule review is still underway, and we are looking closely at the comments, and more will be coming in the future.
Thank you. I want to just close by thanking all of the witnesses for this excellent testimony. It's been a great start to our subcommittee's series of hearings. I hope we will explore more of the COVID scams that we're seeing multiplying and exploding literally every day. I think education, Ms. Patton, is a very important component here, but as you've described so eloquently, there are enforcement actions that need to be taken as a deterrent, as a source of restitution, and as a punishment. And I'm hoping that the FTC will play an increasingly vigorous role with additional resources that are absolutely necessary. And as to the tech platforms, we need to make them accountable for enabling these kinds of scams. And thoughtful revision to Section 230 is key to that effort. Thank you to Ms. Alexander, Mr. Rhodes, Professor Kovacic, and to Mr. Kaufman and Ms. Patton. Really appreciate you being here, and thanks to my colleagues, especially Senator Blackburn. We will remain open. The hearing record will remain open for 2 weeks. Any senators who'd like to submit questions for the record should do so by May 4th. We ask that your responses be returned to the committee as quickly as possible, and in no case later than 2 weeks after you receive these questions. That concludes today's hearing. Thank you all. Thank you.